Hi everybody, we're back to class and we're now going to look at your PowerPoint, which is called Mandatory Mediation and Arbitration. Okay, so let's have a look at our first page, Mandatory Mediation. This is under Rule 24.1 in the Rules of Civil Procedure and establishes mandatory mediation for cases managed that are not family actions. So you'll find out in Toronto, Ottawa, and Windsor, it's mandatory that participants take part in 3 hours of mediation. Case management is a system in which the court supervises cases and imposes strict timelines on their movement through pre-trial and trial processes. So mandatory mediation started in 1999 by a woman who was an instructor of mine by the name of Leslie McLeod. She saw a need and designed this program. She's got a really interesting history if you ever want to Google her, including spending some time in the Philippines doing dispute resolution with elders there. So mandatory mediation is designed to help parties involved in civil litigation and estate matters attempt to settle their cases before they get to trial, thereby saving both time and money. Under the program, cases are referred to a mediation session early in the litigation process to give parties an opportunity to discuss the issues in dispute. With the assistance of a trained mediator, the parties explore settlement options and may be able to avoid the pretrial and trial process, which of course is the point. So if you go to slide, I lied to you. We are on slide 4. It says Rule 24.1 in Toronto, Ottawa, and Windsor. So civil cases, except family, that are defended are referred to mediation. Cases may be exempt only if the parties obtain a court order. Mediation is conducted by a private sector mediator or somebody on the roster, and the parties can agree to that person that they want or have someone from the roster. The decision must be made within 180 days after the defense is filed. If the parties cannot agree on a mediator, one will be appointed by the local mediation coordinator who is responsible for administrating the program. So I'm on that roster. And what I get is I get a document that has the name of the parties and the name of the law firms, a little history of what's gone on, and that's it. You're lucky if you get contact information. And if you Google some of the lawyers, you'll find out what sort of case it is, because sometimes you just don't know. Okay, so must take place within the mediation must take place within 180 days after the defense is filed, unless the court orders otherwise. Parties can agree to postpone the mediation to a later date, filing a consent with a local mediation coordinator. It's been done. Doesn't happen that often, but every once in a while things happen, as we all know currently. At least 7 days before the mediation, parties must provide the other parties and the mediator with a statement of issues. And I'm just writing something down here because it's relevant. Okay, so 7 days before, the other parties and the parties must provide a statement of issues to everybody, including the mediator. So everybody knows exactly the playing field that everybody's coming from. It identifies the issues in dispute and the parties' positions and interests. The pleadings and any documents of central importance to the case must be included. So usually I've received anything that's from 7 or 8 pages to binders this big, and you're looking at it going, oh my gosh, because sometimes you're reading people's medical histories that really are relevant, but you're really privy to some very, very confidential information. And as I said, everybody gets exactly the same information. So if you turn to slide 5, we're going to look at Rule 75.1. Proceedings related to estates, trust, and substitute decisions are referred to mediation unless exempted by court. Within 30 days after the last day for serving a notice of appearance, applicants are required to bring a motion for direction relating to the conduct of the mediation. At the motion for directions, the court may direct such matters as the issues to be mediated, who has carriage of the mediation, the time frame, which parties are designated to attend mediation, how the designated parties are to be notified of the mediation, how the cost of the mediation is to be shared along with the parties. So following this motion, the parties are required to select a mediator within 30 days. I do just want to back up. I want to back up to that piece about at least 7 days. So I'm sorry, we are going back to slide 4. At least 7 days before the mediation, parties must provide the other parties with a statement of issues. So what will happen is the mediator, if the mediator hasn't received their statement of issues 7 days ahead of time, they can issue what they call an order of non-compliance, which means the lawyers have not complied with what's going on. And it's fairly serious. I've only done it a couple of times. The 7 days is meant to prepare the mediator to give them time to read what's going on, answer any questions. You remember when we do the mediations in class, I have you look at 3 questions. What are the general issues that come up? What general questions do you need to ask? And is there anything there you don't know about? And you've got to do some research. So this is where you might come across that third piece. Is there anything that's been brought to your attention in the statement of issues that you're unfamiliar with, that you might need to do a little bit of research on? Okay, so thank you. We looked at page 5. We've looked at. We're going to go to slide 6. And this is Rule 75.1 continued. So mediation is conducted by a private sector mediators, and again may agree to select a mediator from the roster or one who is not on the roster. So a party with carriage of the mediation is required to give the selected mediator a copy of the orders giving directions. If parties do not select a mediator within 30 days, the party with carriage of the mediation must immediately file with a local mediation coordinator and request to assign a mediator. And then again, the mediator, whether assigned or selected, is required to immediately fix a date for the mediation at least 20 days before that date, serve on every designated party a notice of the place, date, and location of the time. And again, 7 days before the mediation, you need to get the statement of issues. So sometimes it's left to the mediator to, if you're selected, because you're on the roster, you get to carry on a process called canvassing for dates. And it is challenging because what you're doing there is you are literally contacting the law firms to say, we got to get this done. Like, we got to pick a date. And that means the lawyers have to then contact their parties, and that's on both sides. So you're dealing with your schedule, probably 2, maybe 3 lawyer schedules and their clients to get a date where everybody can come together. That process is called canvassing for dates. It's extremely challenging. And there you go. So that's part of the pleasure of the job. So now we're going to go to slide 7, and we're going to look at mandatory mediation location and attendees. So if you are lucky enough to have an office, that's ideal. If you have somebody who has an office, somebody that you know, and there's no conflict of interest, and they don't mind you using 2 rooms, because mediation, remember, is always a room for joint session and the breakout room, you can go to one of the offices of the law firms as long as the other party agrees. That has happened. You just ask, are you okay? Because what happens then, as you can imagine, is you have power. You have what is potentially a perceived power imbalance if you're going to one law firm instead of the other. There are places that will rent. I've talked about that in class before, Network North and Victory Verbatim. You have to find out if the parties are willing to pay for those locations, because as I've mentioned to you before, they do have this running buffet. And the running buffet is, in addition to feeding everybody, It is meant to psychologically bring people together because they talk over food. So usually in some of these locations, you'll see counsel sort of, talking about whatever over, the smoked salmon on a bagel or a spring roll or a piece of cake or a muffin or something. Or they're talking to each other, how's the family, what's going on. But food does bring people together, so it's a great place if people can afford it, and it's not cheap. So also the Ministry of the Attorney General in downtown Toronto offers free suites that you can call the mandatory mediation office and just ask to have 2 suites for the mediation. And I'll put it to you this way: it's got tables and chairs and windows and doors, and phones if you need it. And I think even one has a whiteboard. So it's good space. There you go. So that's very nice. So that's an option. All parties must attend the mediation. If a party is represented by a lawyer, the lawyer must also attend. Yeah. The lawyer may not attend in place of a party. For the mediation to proceed, parties must have authority to settle. And again, right here, we talked a lot about authority to settle in class. And I think I even gave you an example where one of the mediators found out that one of the parties to a mediation did not have authority to settle. And that was like 5 hours of a mediation basically wasted. We talked about that a lot. For the mediation to proceed, the parties must have the authority to settle or have ready telephone access to anyone whose approval is needed to settle. So that's pretty good nowadays. So let's flip the page to page 8. So mandatory mediation agreements. If an agreement, and this is if an agreement is reached, because it's you are providing the opportunity. You're not guaranteeing resolution, because you remember we talked a lot about it in class. It is not your business if the parties do not settle, and it is no reflection on your skill set. Okay, so if an agreement is reached at mediation, it must be in writing and signed by the parties or their lawyers. If the agreement settles the entire case, the defendant or the defendant's lawyer must file a notice with the court advising of the settlement within 10 days of the agreement being signed. And I'll tell you why that's why the actually it's the mediator that I have always known that does that. So the mediator will send a note. Maybe the defendant's lawyer does the same thing, but a mediator is also obligated to file a report that says the mediation was either settled or not settled. And the document's really, really straightforward. Who are the names of the parties? What's the date? What's the court file? It gives you little options as to how many people were at the mediation. Is this a 2-party, 3-party, 4-party mediation, more? So you're going to check that off. What was the date you had the mediation? Did it settle, not settle, partially settle? And that is all that they want to see, because that agreement is confidential. So, and the reason why there's a 10-day window there is because the 10 days was a very deliberate choice on the part of Leslie McLeod, because she said that if you go to mediation and it doesn't succeed, it doesn't mean that that both parties aren't then going to reflect on what they discussed and then perhaps think that maybe they should settle, partially settle, agree to those sort of things. And the 10-day period is like that sort of cooling down period where you can sort of think about what took place. So the court actually provides that window very, very specifically. So usually what will happen is a mediation will end, and I might wait the 10 days before I submit my document, just in case something happens along the way. And it can still settle after that. Okay, so agreements reached at mediation are legally binding if a party fails to comply with a signed agreement, and any other party may take a motion for judgment under the terms of the agreement or continue legal proceedings as if there had been no agreement at all. If no agreement is reached at mediation, again, it does not mean you've done a bad job. So what will happen is each party will gain a better understanding of where that other person is. It can at least narrow the issues in dispute, settle some of the issues, agree on a process to resolve issues later in the proceedings, which is really interesting. Lawsuits that do not settle are going to continue to court, and information arising from the mediation is confidential and cannot be used outside. And we talked about that in our agreement to mediate. Everything that's said is confidential. So in one mediation I had, the suites that I was using for the mediation were under construction. The whole floor was under construction. So I've got my two parties standing together, which was not great, and we had no access to a room. So, and it's an office building. So I run downstairs. We knew there were 6 issues on the table. Find the building manager, and then within the time I found the building manager, got back upstairs, those 4 out of the 6 issues had been resolved. And there were 2 on the table, just because they were standing there. The council had nothing else to talk about. So they decided, why not resolve? Interesting situation, though, because the lawyers were very, very open-minded to settle. They wanted to settle. So they were practicing true collaborative mediation, which is really interesting. So we're then at mediation for the 2 remaining issues that did not resolve. So the mediation's over. They've resolved 4 out of 6. 2 outstanding did not resolve. Then mediation's over. I wait that 10-day period. I get a phone call to say they resolved it. So interesting how things turn out, and also how things turn out, and also how lawyers and counsel and parties, if they go in with a positive collaborative mindset, willing to listen, you never know. And in this week's class, you're going to see a document on how counsel can sabotage mediation. And I've shared some of those experiences with you. It's quite fun. And a great learning experience for you guys. Okay, we're going to flip to slide number 9, choosing a mediator. Lawyers and non-lawyers are qualified and trained to mediate disputes. Parties should feel comfortable with a mediator. Remember, we always talked about rapport. The mediator's training, experience, knowledge about the court process, and familiarity with the kinds of issues involved in the lawsuit, they could be looking for that. Mediator's approach to mediation. So we talked once about there's 4 different types of mediation. We focused on 2. We talked about facilitative mediators, and we talked about evaluative mediators. And that Alan Stitt in the Simmons Funeral Home was absolutely what you would call a facilitative mediator. So he facilitated a conversation. And the evaluative mediator, you remember when counsel kept saying, what do you think our chances are? Do you think we're going to win? What do you think here? What do you think there? And Alan Stitt kept deflecting everything. What do you think? Right? So an evaluative mediator would have answered that. I think your chances are about 30-70 that you're going to lose. So we learned in class the facilitative model of mediation. There's also transformative, and another one that slips my mind, but I can get back to you with a note if anybody's interested. But we learned the facilitative model. Now, some lawyers would probably prefer an evaluative mediator, but if you're familiar with the process, your role is to get people talking. So that's good too. So that's your approach. Your mediator's fees and expenses and references. So who pays for the mediator? Split down the middle. So we've talked about that as well. And it's sadly the fees for the mediation, according to the mandatory mediation program, have not changed since 1999. So if there's 2 parties, it's $600. 3 parties or more, it's $675. 4 parties at $750, and 5 or more, it's $825. So that is usually just divided equally amongst the parties. every once in a while, I think I told you that you become a, I'm not paying for Helen, you pay for Helen. I don't want to pay for Helen. Okay, let's just split her down the center. But anyway, so every once in a while, you do become a bargaining chip, which is kind of humiliating and awkward. Okay, so if this session, here's the big question, right? So if the session isn't finished within 3 hours, mediation may continue with, if session isn't finished within 3 hours, so it goes longer, you can go on, but you get to charge your normal rates, which will not be $200 an hour. So, so that's kind of the rule of thumb there, that if it's up to 3 hours, you charge the mandatory mediation rates, and if it goes beyond the 3 hours, your regular hours kick in. All right, so that's the Ontario Mandatory Mediation Program. We're going to now move to arbitration, and we talked a little bit in the class earlier that this is now, when you look at that ADR continuum, you are now moving into a rights-based process where the parties are starting to lose their power. So a neutral third party is empowered by the parties to decide the outcome of a dispute after an informal hearing, which usually includes a presentation of evidence and oral argument. Okay, so the parties and the arbitrator can create whatever agreement to mediate. And remember, we looked at agreements to mediate that they want. It can be very specific, but there are certain things that you can include in the arbitration process, and there are certain things that you cannot exclude. For example, you cannot take out or write into an arbitration agreement that you don't have to pay the person that you owe. Things like that, or that, you cannot write that in. So if the parties agree, among other things, they have the option of introducing elements of informality. So simplifying the process so it's outside that courtroom setting. Permitting the matter to be presented through written arguments and documents without the attendance of witnesses, ensuring that the arbitrator's award or decision is final, and that there is no right to appeal to the court in any circumstances. They may also agree to the following. The arbitration procedure will be more stringent than found in the public court system. A panel of arbitrators, and not just a single arbitrator, will hear the case and render a decision, and either party, as of right, may appeal the arbitrator or panel award on an issue of fact or law or mixed fact or law. So this is really interesting too, because in the arbitration process, let's say you go for a panel of 3. You can have, I talked about it briefly in our previous video. So you can have one arbitrator, you can have a panel of 3. One is sort of the lead arbitrator. The other 2 can be hired by either party because they might be subject matter experts in the field that best represents their client. So you've got neutral arbitrator, arbitrator favoring one side, if we could use that word, arbitrator favoring the other side. You can do that so that they can sort of provide an entirely well-balanced process. So arbitration is really, really interesting. Okay, I continue. We're on slide 11. Okay, so arbitration is appropriate in those cases where the parties all agree to submit their dispute to arbitration rather than going to court. Most likely these parties have decided that they cannot resolve the dispute among themselves, that outside conciliators or mediators will not assist them, and they therefore wish some other person to impose a decision that will be binding upon them, whether or not they like the decision rendered. Now, here's something else that's really interesting when it comes to arbitration. Sometimes arbitration is more expensive than hiring a lawyer to go to court. So it is not necessarily the cheapest route going. And that is because, let's say you have a panel of 3 arbitrators. You got to pay all 3 of them. And their rates might be a little bit different to that of a lawyer. So these are things people have to weigh when they go to arbitration. So we're going to move to slide 12. So hold on, slide 12. I'll just get that because we have a lot of notes here on slide 12. So it's voluntary or mandated, so parties must expressly agree to arbitrate in writing or fall within the ambit of legislation that mandates arbitration in a given situation. Control. The parties and their counsel are able to control the process. We talked a little bit about that. And again, you can have it at somewhere neutral. The timing might be easier, the location, and who's going to be present. It's usually a private process. It's informal, subject to the Arbitration Act. There is no prescribed procedural or evidentiary rules governing arbitration. The rules of procedure are established by the adoption of existing rules, by a negotiated arbitration between the parties, or by the parties and the arbitrator. Adjudicative. As in legislation, once a case has been presented by each side, an arbitrator issues a decision. The arbitral award must be in writing. Must. And reasons must be provided unless the parties have agreed that there are no reasons required. So I can't speak to that. So I find that really fascinating. So binding and non-binding. So if the arbitration is binding, then a review of an arbitral award is available only on limited grounds, such as incapacity of a party, invalidity of an arbitration agreement, or that the award is in violation of law or public policy. So it's got to be, the arbitration is confidential if the parties elect it to be so. Adversarial. While the arbitration is based on the adversarial style of the litigation model, the demeanor and nature of the hearing are determined by the parties, the counsel, and the arbitrator or arbitrators. It's flexible. The parties have discretion in choosing an arbitrator and the procedure to be followed in resolving the dispute. We are still on slide 12. So, the process is often a creature of the parties and can clearly maintain control over the design of the arbitration process. Sometimes the scope of the arbitration process and its rules are set out by statute or contract, or in other situations, the parties work together to design an arbitration process that is appropriate specifically to their dispute. Some cases, parties choose the arbitrator, limit the length of the opening statements, so each party has that opportunity to say. So they, you got 5 minutes, that's it, then we're cutting you off. So they can limit the length of the opening statements. Of course, 5 minutes might be too little. Or may decide that there will be no oral discovery, no oral hearing. But once the parties set the parameters for the arbitration, the arbitrator assumes control of the process. It's private. While, in general, court processes and decisions are open to the public, arbitrations are conducted with only those and their privies present. The proceedings and awards are confidential as long as the arbitration agreement so provides. The confidentiality is compromised, however, where court intervention is sought. So procedural reliefs or appeals, for example. Custom dispute resolution. Subject only to the Act's exclusion, the Arbitration Act, arbitration agreement may be crafted to fit the dispute. It's such an interesting thing. And sometimes a great deal of time can be spent just crafting what that agreement looks like. Okay, this is an important feature and potential advantage of arbitration and contrasts significantly with the rules and procedures generally applicable to all civil actions. Okay, so parties may structure the arbitration as they deem necessary, subject to certain provisions in the Act, namely the Scott v. Avery, and I will get that to you shortly. Equality and Fairness, Section 19. Section 39, its extension time limits. Section 46, setting aside the award. 48, declaration of invalidity of arbitration. And 50, enforcement of the award. I will, as I said, I'll get that Scott v. Avery clause for you. Procedural efficacy. Litigation by its nature is adversarial, so is arbitration. If conducted in a timely, orderly, and procedurally functional manner, is an efficient dispute resolution mechanism. Essentially, the Courts of Justice Act and the Rules of Civil Procedure. Okay, there are exceptions to the general application of the rules. For example, the rules with respect to mortgage actions as set out in Rule 64 of the Rules of Civil Procedure. Section 3, an agreement requiring or whose effect is that a matter be adjudicated by arbitration before it may be dealt with by a court. 5 to 10, a familiar complaint against litigation is the seemingly pointless interlocutory steps taken on the way to the courtroom for final judgment. Litigation has a fixed set of rules that permit parties to engage in seamlessly endless interlocutory battles. Trial dates are often distant and do not always proceed as schedule. Careful drafting of the rules of the game and injecting timeliness and certainty into scheduling are all at the core of a well-drafted arbitration agreement. So true. Arbitration agreements may be drafted so as to limit or even eliminate many procedures that are permitted in litigation before the courts and their impact on the timely and efficient resolution of the dispute on a fixed and certain date. Moreover, arbitration offers the flexibility to empower the arbitrator to render timely and binding orders on interlocutory matters without costly motions. So I did take an arbitration course in the fall, and there is a section in Section 3 of the Arbitration Act that talks about the various sections that you cannot opt out of, such as, let me see if I can, let's say the awards or equality and fairness. So it lists all these different sections that you cannot, in this one section, it lists all these different bullets that you cannot opt out of. But what it doesn't say, apparently, so let's say it's Section 3. So it says you cannot opt out of 3, A, B, C, D, and E. But nothing says you can't opt out of 3. So because it doesn't say that, then doesn't mean that you can actually then opt out of it. So I could get you more information on that too, if anybody wishes. So we're still on slide 12, and we're looking at the cost and the time. So basically, sometimes litigants or their counsel lose sight of the objective, as I'm sure we all know. The long road to trial can seem filled with unnecessary and costly pit stops. This lack of focus is often at the roots of parties' dissatisfaction and the cause of delay and cost-driven settlements rather than merit-driven settlements. By constraining the process and shortening the wait for the hearings on the merits of arbitration may provide the opportunity to move things forward. Arbitration may be crafted so as to lessen parties' adversarial tactics, including mandatory but regulated mediation and non-binding arbitration. Litigation, by virtue of these regulations and all too often marginal disputes, combined with an inordinately long time frame to get to trial, tend to increase costs and engender a confrontational relationship, injecting emotion into the resolution of a business dispute. These costs and emotions often serve as obstacles to a resolution, which we've all talked about in class and in the mediation process too. In other cases, they lead to settlements based on economics and the need for resolution intensified by a seemingly never-ending process. It's sort of like somebody saying, I give up, just do whatever they want. Okay. Necessary focus to allow the parties to secure a cheaper and faster resolution than litigation. Again, not necessarily true. In litigation, unlike arbitration, the parties do not directly pay for the judge, the courtroom, and the court reporter. For many disputes in arbitration, these are additional costs. So arbitration agreement may be drafted so as to limit costs and effect a speedy disposition. So that's neat too. You can say, listen, I want this over with by August 2020. Okay, so how about I'm going to pause here and we'll say this is video entry for this particular section, number 1. Part 1, I'll call it part 1 of this particular class, which is mandatory mediation and arbitration. Okay, so I'll see you shortly.